Hello and welcome back to Take from Caesar. My name is David Myrland. Nothing you'll hear me say is intended as legal advice. Anything that sounds like that to you, just consider it something somebody else might do on a planet far, far away where the law matters. It doesn't matter here. I prove it on a daily basis. Believe it. Toilet number one, the judiciary. America's best non-flushing toilet. The mind of every judge. And anybody that would allow a judge into their life. They go to your churches, their children go to your kids' schools, and it's obscene. The judiciary is America's number one problem, undetectably so due to ignorance of the law. If you don't know the law, you can't detect corruption. It's that simple. Corruption is criminality, conduct that offends criminal statutes, and the judiciary is king, but you don't know that until you know something about the law. But I'll tell you what, it was about 2000 or 2001, I started reading the criminal code. I said, this is government's home address. And all I've seen since then is confirmation, affirmation that that is precisely where the government lives, exists, operates, and from which it can't be rescued. It's called criminal insanity, and that's the judiciary. This is tax code section 61A, gross income defined. It begins by saying, except as otherwise provided. As otherwise provided? Yeah, like section 212. In the case of an individual, there shall be allowed as a deduction all ordinary and necessary expenses paid or incurred in the production or collection of income. Yeah, it's called cost. Cost is not gross income. They won't deny you that. But when it comes to tax code section 83A, that everybody agrees explains how to tax your paycheck, we're going to look at a stunt pulled by a baby raper, otherwise known as a judge. That's what ignorant people call judges. That accomplishes the government's goal of contradicting the law to make money. That's called racketeering. That's a felony. It's called a conspiracy against your rights and my rights. That's a felony. 18 U.S.C. 241. And it's in plain sight when you know the right things and ask the right questions. We're only going to spend a moment in the law. This is predicate upon your having first viewed my tutorial about tax code section 83A on my YouTube channel here, Take from Caesar. Watch that video. It's 2.5 hours long, section 83A tutorial. And it's everything I think you need to know about section 83, that which the courts say explains how to tax all compensation in the country, self-employed and employee. So you take that tutorial and then watch what I'm able to do to a tax court decision that runs from tax code section 83. In a court that says in Cone versus Commissioner, 1974, section 83 applies to all property transferred in connection with the performance of services to independent contractors and employees. You can't have it. Just try to argue it. They'll penalize you thousands of dollars for being frivolous, and they won't get into the language of the statute at all. Period. It's off limits. You can't have it. And they run back to section 61A that says compensation for services including fees, commissions, fringe benefits, and similar items. All of it is gross income, except as otherwise provided in this subtitle. Subtitle, that's chapters 1 through 6 of the tax code. We won't leave chapter 1 in this exercise. That's the chapter they say imposes the Section 1 income tax on all citizens of the United States. But we have an instruction in Section 61, 61B, For items specifically included in gross income, see Part 2. That's Section 71 through 90. Section 83 is right in the middle of that, isn't it? Yeah. And so we have a law that instructs us to consider Section 83, and we got plenty of authorities that say Section 83 explains how to tax compensation. It applies to all of it. Revenue Ruling 2007-19 says Section 83 provides for the determination of what is to be included in gross income. And we're going to look at a quote from a tax court case from 2017 that throws all that away to escape the language of Section 83, as I described in the video, the Section 83A tutorial. You also want to watch the video on my channel about Revenue Ruling 2007-19. Everybody agrees it's Section 83, but when you press it, they run from it. And I'll show you an example of it from 2017. I knew this already. 5 trips to the Supreme Court by October of '98. That was in another century. And they did the same thing. So since 1996, I've been teaching that the best you can do, because it's only America, the best you can do is to start a home business, gather all the allowable deductions H&R Block says you can get away with, teach your children how to run a business at home, and stay in the system, or you have a relationship with a government that is not a strict cop. The government is a horde of carjackers with pistols in prisons, and they don't care about you, and they don't care about the law. The judiciary, over and above that, the judiciary hates innocent people. A judge in America cannot raise a normal child. And I would sooner presume that every relative and friend of a judge rapes babies right alongside of them. Because the law doesn't count when you're a friend of the judge. They'll set it aside to get you off of charges of baby raping. That's the American judiciary, the #1 toilet. It doesn't flush. You can't tell because you're ignorant of the law. If you're not ignorant of the law, you know I'm not talking to you. So relax. But what I'll show you today is bona fide, clear proof, evidence that judges are the enemy. Period. I got all the proof. We're going to watch it right here, right now. 61A, gross income. Oh, that's everything. It's everything. No arguments. It's everything. No, it says except as otherwise provided in the subtitle. Section 212 is a section they'll honor. Let's see. Pardon me. A 151D and 63C, personal exemption and standard deduction. That's an exception they honor. Well, how come Section 83 is off limits when it explains how to tax my paycheck? It explains whether or not I have a relationship with the IRS. And if it does not include in gross income the value of my labor, every contact from the IRS is evidence of a felony. Mail fraud, 18 U.S.C. 1341. And conspiracy against rights, 18 U.S.C. 241. But you won't have a judge in the country that'll honor the law. And what you're going to see is that, the law does not displace this general rule. It better be a general rule from Congress. The 16th Amendment says Congress can lay and collect this tax. And yet we're going to see that that general rule is the sole basis for moving all of your paycheck from the category of cost into the category of profit or gross income with a general rule and not with a statute. Who's that general rule from? I need a list of the general rules and I want to see the language of the general rules, please. No. It just rears its ugly head when you get to court. I relied on the law. Well, you shouldn't have done that. We got a general rule that screws you. Oh, so you can't rely on the law. You pay because of the judges. You do not pay because of the law. And we're going to see proof of it from a tax court decision in 2017. Proof of it in writing that every judge rapes every baby. The law is last. The court's general rules are first. And in this instance, it makes all the difference. What is this instance? Whether or not you pay when all you've done is sell your labor as an employee or as a self-employed individual. How about that? We're gonna push it into the ground like a thumbtack and nail tax court for what it said in a 2017 decision. So, like I said, #1 toilet in America, the judiciary. Their minds are open sewers. And if you would let a judge attend your church, if you would let a judge's children go to the school where your children go, you get the country you deserve. You get the family you deserve. Why would you want the child of a judge anywhere near your family? So again, except as otherwise provided. Oh, we won't talk about that. This is an American court. Nothing is provided anywhere else. There are no exceptions. You owe money. And you raise an exception to it, and they penalize you thousands of dollars for doing it. So again, B, for items specifically included in gross income, C, section 71 through 90. Okay. It doesn't matter in America. You show this to a judge, you lose. Here's section 83 of the tax code. First, a review of just how relevant it is. Section 83A explains how property received in exchange for services is taxed. It didn't say some property. Footnote #1, Montalepre Systemed versus Commissioner, 5th Circuit, 1992. Okay, and they don't disagree with this until you push them. Well, the law, section 83, doesn't displace this general rule. I need a list of those general rules, and I want to see the text of all those general. Well, they don't exist. It's in the mind of the judge. Whatever it takes to screw you is a general rule. Anytime the law protects you, the judge will screw you with a general rule, and it's the reason you pay. Section 83 applies to all compensation paid for services of corporations and for the services of individuals. Footnote #2. And you can pause anytime you want to read this. It's in the video on Section 83, my tutorial. Labor is property. Footnote #3. Yeah, Supreme Court. It's your most sacred and inviolable property, since it's the foundation of all other property. And think about that. Without labor, you don't even have a loincloth to cover yourself while you go out smashing beetles with rocks for breakfast. Labor is the foundation of everything above a naked human smashing beetles with rocks to eat them. Labor labor results in everything above that. The fair market value of property is established through the terms of an arm's length transaction. Footnote 4. The arm's length transaction this is Black's Law Dictionary, 6th edition, page 109. Set of a transaction negotiated between two unrelated parties acting in their own best interest under no compulsion to buy or sell, all relevant facts disclosed. That's me and my employer, me and my client. See how that works? That establishes the fair market value of the personal services. And you can pause this. There's Robinson versus Commissioner, 1984. Cohn versus Commissioner, 1979. Excuse me, I thought that was 1974. This is what always confuses me about citing Cohn, is that 73 right there. 73 USTC 443,446. And then I accidentally say 74 too often. My memory is not perfect, although vast. Had the Department of Justice tell me, You do have a fantastic memory. Well, thanks. Don't forget that. McNaughton, 6th Circuit, all property transferred. Pledger versus Commissioner, 5th Circuit. Alves versus Commissioner, 9th Circuit, all property transferred. No, 61A, we are going to talk about Section 83. Section 83 is a game changer. I wrote a manual about it in 1994, early 1994, called Codebreaker, the Section 83 Equation. I added 30 pages to it in 2014 to bring it up to date. It's available on wevgov.com, wevgov.com, products page, and I'm the only one teaching it. David Champion and Pete Hendrickson look at it and they go, it's gibberish. It's a ridiculous argument. Get to the part where I'm wrong. The courts can't even prove me wrong. They have to play evasive games to get away from Section 83, but David Champion and Pete Hendrickson know all about it, and it's gibberish. Now, it's gibberish to people that can't read. There you go, Pete. You can't read it. That's why you have to call it gibberish. But you don't have that luxury. It explains how to tax all compensation. And here's Internal Revenue Ruling 2007-19. Section 83 provides for the determination of the amount to be included in gross income when property is transferred to an employee or independent contractor in connection with the performance of services. This is the IRS that says this. And we already have all the courts on the appellate level. Then we have the Supreme Court in U.S. versus Lanier citing these other cases. We have referred to the Court of Appeals when inquiring whether a right was clearly established. So it's clearly established law that Section 83 governs. Well, you can't have it. We aren't going to talk about it. And this is a quote from Talmadge versus Commissioner, 1996. He was penalized $6,500 for saying this in open court. I will concede all facts of the case today if they'll just tell me how to comply with Section 83. This judge can't even speak a language. That's how hard they have to run from Section 83. Go ahead and pause this and read that paragraph. In attempting to equate his wages with property for which he has a tax cost, no, he isn't. He's saying that his labor is cost, all property is cost. So they have to mischaracterize the claim. The worker's cost for his services, and thus his basis, is zero, not their fair market value. Do you see him get into the language of Section 83, or 1.83-3G, that says, for the purposes of Section 83 and the regulations thereunder, the term amount paid refers to the value of any money or property paid, the value of it. Well, I paid 40 hours of labor. What's its value? It's what an unrelated party is willing to pay me for it. And only the excess over that amount is gross income. They don't get into any of that. They can't afford to. And this is the appeal that I wrote. This is a 1995 client of mine. We affirm based on the reasoning of tax court. Okay, so on the appellate level, that's clearly established law. That without getting into the language of the statutes at all, we simply exclude from cost the value of your services. Without reference to law, it's arbitrary. When law says the amount paid is everything. You can pause and read this. Now, regulation under Section 83, to figure your cost, which is your basis, shall be determined under Section 1012 and the regulations thereunder. And here's the regulation thereunder. The cost is the amount paid for such property in cash or other property. Well, labor's property. Well, no, not labor. But the law says any property. No, you can't have it. So, this is a case about the term any. Monsanto was a heroin manufacturer and distributor that got busted. And pursuant to the federal drug forfeiture statute, they seized any property. That included all of his money. And he said, hey, you got to leave me money out of my money for attorney's fees. And the Supreme Court said, no, the language of the statute says all assets are to be seized, with no exception existing. Well, where's the exception for labor when the law says any money or property is a cost? They don't need an exception. They have a general rule. Isn't that neat? Congress, the 16th Amendment says Congress can lay and collect an income tax. And when the law imposes the income tax, it provides for all property being cost. And a general rule comes along and is imposed on top of it, a rule that did not come from Congress, that takes everything, the value of your labor, from the category of cost and puts it in the category of profit or gross income. It's a general rule. And the law does not displace a general rule. Oh, so if I rely on the law, I find out when I get to court, oh no, that law is void. We go by general rules here in this court. I need a list of those general rules and the text of each of them right now. No, they're unwritten, unspoken, and you don't find out till you go to court. Ha ha ha. That's how the government wins. America calls that a victory. And you think government is honest? Be the fool. Yeah, this is toilet number 1, the judiciary. Toilet number 2, the anti-tax movement. So, 1.83-3G. For the purpose of Section 83 and the regulations thereunder, the term amount paid refers to the value of any money or property paid. No, it doesn't. We got a general rule. Boy, I would have liked to have known that when I read the law. See what happens when you finally find a protection in the law? They do anything they have to deprive you of it, while they extort money from your family to a degree that leaves your children malnourished and unkempt. The law does not provide for an exception to this standard, which the Supreme Court said must exist for any exception to be upheld as lawful. Yeah, exactly. So, we have this situation where the law says any property is a cost, and the government says, oh no, general rule, labor's not a cost. And that dynamic, that reasoning, solely that reasoning, drags from the category of cost into the category of profit the value of your labor you received as paycheck or fees, commissions from an unrelated party. Isn't that easy? Now, this is from the Robert Orth case. As we see, it's October 12th, 2017, in U.S. Tax Court. Child molester Ronald L. Buck. I should say Grand Dragon child molester. So, Mr. Orth makes the frivolous argument about the application of Section 83. He claims that Section 83 does not apply to compensation for services. Wrong. He claimed the opposite. He claimed that Section 83 applies to all compensation for services. This is a Freudian slip by the judge. He wishes that Section 83 did not apply to compensation for services. But you can't deny that the petitioner did claim that Section 83 applies to all of it. It explains how to tax it. I wrote the brief. You think I would claim Section 83 doesn't apply? I've been writing the opposite for dozens of people since 1992. So no, this is a Freudian slip. The judge wishes it did not apply to compensation. We move on. But Section 61 includes in gross income compensation for services, except as otherwise provided. That's the burden of proof statute. If you can't prove something is not gross income, they'll tax it as if it were gross income. But once you prove that something is not gross income, oh, we can't have it. Section 61 includes in gross income compensation for services. What about the statute that explains how to tax my paycheck? Oh, no. We're not going to talk about it. Section 83 is one of several provisions that specifically include items in income, but it does not displace the general rule that compensation for services is income. Really? So Mr. Orth's Section 83 argument is frivolous, and we have previously held that it is frivolous. Footnote 6. Now, the law, Section 83, does not displace the general rule? Oh, I want to see that general rule. Give me the book of general rules, because it obviously conflicts with the law. When you have the government in the Supreme Court 5 times, it won in the Supreme Court, arguing that the term any or any property means all of it, unless the law contains an exception. Oh, not here, not now. We just do what we want under general rules. That's a baby raper. We have a general rule that if it conflicts with the law, the general rule prevails. And so we call it a tax. Well, the 16th Amendment says Congress can lay and collect this tax. Where's the judiciary's authority to drag the value of my labor, your labor, from the category of cost into the category of profit? Because you're looking right at it. A general rule. It better be published. It better be from Congress. Yeah, it better be. Doesn't have to be, because America has no courts. It simply has a bunch of baby rapers that call themselves judges. You're looking right at it. Section 83 does not displace the general rule. Well, if you honored Section 83, it would displace that general rule. No, I'm a judge, and so you're screwed, and you don't find out till you've been to court. This is the Pagel decision. We shall begin our analysis with an exegesis, that's an interpretation, of the general provisions of Section 83. We then shall examine those provisions in conjunction with the facts of the instant case, so that we may decide whether respondent adequately notified petitioner of the issue of the applicability of Section 83. Section 83A generally provides that where property is transferred in connection with the performance of past, present, or future services, the excess of the fair market value of the property over the amount paid for the property is includable as compensation in the gross income of the taxpayer. They don't cite a general rule here, do they? They go straight with the language of Section 83. Section 83 does not apply only to employees of the transfer of the property. Rather, it is applicable to any person other than the one for whom the services were performed. That means anyone but the employer, including independent contractors. Did you hear them draw upon a general rule? No. They went straight with the language of Section 83. It was a case about non-cash, non-money compensation, but they went straight with the language of Section 83. That's a 1988 case. And now we have Sigmund Coal Company, Sigmund Barnhart, Social Security Secretary, versus Sigmund Coal Company. As in all statutory construction cases, we begin with the language of the statute. The first step is to determine whether the language at issue has a plain and unambiguous meaning with regard to the particular dispute in the case, unless there's a general rule. No, they don't say that, do they? It's about the statutes only. The inquiry ceases if the statutory language is unambiguous and the statutory scheme is coherent and consistent, after the court has considered all general rules that are non-published, non-spoken. Oh. So you take this and you have to graft onto it tax court's reasoning. Oh, we got general rules that contradict the law. We go with the general rules first. It better be a general rule from Congress. Congress doesn't write general rules. I got news for you. Congress writes statutes. How about that? So Mr. Orth's Section 83 argument is frivolous, but we can't say why. It's just because of a non-spoken general rule he didn't know about. It's non-spoken, non-written, non-recorded. It's not part of the law, and he's frivolous for not knowing that. So you got to be a scholar of case law to navigate the court system. You can't just do it based on the language of the law. That's the reasoning of a baby raper. Every American judge. I got over 27 years experience since I wrote my first briefs. Every judge. Okay? I've seen justice 3 or 4 times. And those were not in federal court. You lose to the tax man because the IRS owns the courts. Now, Bill St. Angelo was another one of my clients from 95. This is footnote number 6. St. Angelo versus Commissioner, 1996. Let's see. Affirmed. This should say 4th Circuit, I think. Or no, he was on the 9th Circuit. That's right. He lives here in Washington. Notably, Mr. Orth cited St. Angelo. No, he didn't. He listed St. Angelo in a list of victims of tax court that penalized people for frivolity while they can't deny a word about Section 83. He didn't cite St. Angelo as an authority. He listed the St. Angelo case along with others who were penalized for nothing. Notably, Mr. Orth cited St. Angelo in his petition, but we suspect he did so unknowingly. No, he did it on purpose. I've been citing that on purpose for not citing it as an authority, but citing it as in the list of victims of this policy that you'll be penalized for arguing the law in tax court. His petition and his response to the motion for summary judgment appear to be cobbled together verbatim from the tax protester website, wevgov.com. That's my website. And when this came out in 2017, I froze that website to show you that arguing the law gets you libeled by the government when they can't deny a word of it. Cobbled together. It's called a memorandum. And it's not my fault that you have evidence in my arguments strewn throughout the tax code. Cobbled together? No, it's what it takes to brief the entire issue. I'm going to be thorough. And I don't care if you haven't seen it before, you baby raper. But it's not cobbled together. It's assembled and argued succinctly. And on wevgov.com, I just do a sketch of the arguments. You read the briefs in the Robert Orth case. And let's get that to you here. Go to this site. And that'll take you right to the Robert Orth page. Read the exchange of briefs. That was not cobbled together. That was succinctly briefed in a way they can't even talk. That exchange of briefs, the government replied and didn't even mention the controlling provisions. So that's not cobbled together. That's hitting the nail on the head. They can't even deny the arguments. So screw this tax court judge and all the others that came before it. And then he goes, on the internet, one can find many variations of the quote, "Don't believe everything you read," most often attributed to Lincoln. Ha ha ha. Get to the part where I'm wrong. You're telling me that the definition of citizen in section 3121E is a U.S. citizen? When it says, citizen or resident of Guam, American Samoa, Virgin Islands, Puerto Rico, but not otherwise a citizen of the United States? This baby raper says, by evasion, that that is a U.S. citizen when it expressly excludes U.S. citizens. Why would you let a friend or relative of an American judge near your church, near the Parent Teachers Association meeting? Why would you let their children near your school, where your children go? Because this is the sewer that is the mind of every American judge. Ha ha ha, let's make a joke while we can't even refute the argument. So here you have it. A general rule, not a law. Congress doesn't write general rules. I've never read a general rule from Congress, but I've read tons of statutes. Congress writes statutes. There. They don't write general rules. So a general rule is the difference. Section 83 is one of several provisions that specifically include items in income, but it does not displace the general rule. Where the hell is this general rule? I need a book of those general rules, damn it. I believed in the law, and I find out, oh, we tax you based on general rules. They have nothing to do with the law. Oh, okay. The amount the IRS demands you pay on your paycheck, on your fees, commissions, tips, benefits, is racketeering. It's extortion, and that includes Social Security, because Social Security is an income tax. Because Social Security taxes self-employment income, Chapter 2. The income of every employee, Chapter 21. FICA. It doesn't tax all compensation. It taxes income. Section 83 governs how to tax 3121A, wages, 3121Q, tips in FICA. 1402A, self-employment earnings. Section 83 applies to all of it. They're income taxes. And so by this mechanism, they tax you under chapters 1, 2, and 21. And since they take chapter 21 out of your paycheck, they say the employer owes matching FICA, and they steal from the employers too, when in fact they're doing it under a general rule. The compensation for services income has nothing to do with the law. So there's your number one toilet in America, the mind of every judge. Every judge rapes every baby. And if you let them near you, if you let their relatives or friends anywhere near you, you deserve the country you get. You don't value your family in the least. And you probably can't raise a normal child, because this is the mind of every judge. It comes up against the law, it's time to answer to the law, they take an oath to uphold the law. Oh, we got general rules to screw you. Forget the law, we got general rules. That's the mind of every American judge. Why would I say it? Oh, I don't know. In the last 5 years, it's February 8th, 2020. In the last 5 years, 2 lawsuits South Dakota, 2 lawsuits South Carolina, counterclaim in U.S. District Court in Kentucky, Texas Tax Court, appeals on the 7th, 9th, and 11th Circuits, and those 3 I wrote to the Supreme Court also. I wrote all that work on these issues. The counterclaim in Kentucky, a guy was sued for real estate. The DOJ wanted to convert IRS assessments to real estate, saying, hey, we want that real estate from him. And they filed a lawsuit. And he lost that property to his wife several years earlier in a divorce, so he didn't have anything to lose. And I said, you want to countersue? He says, yeah. So he sued them for the clear explanation of the laws that the Taxpayers' Bill of Rights says you're entitled to. And his counterclaim was dismissed. You can't sue for a clear explanation of the law. See? Every judge rapes every baby. When judges aren't raping babies, they're catching their breath. And right behind them is government attorneys. That's a fact. I've seen it, and I've seen it, I've seen it. I've been to court and been to court and been to court and been to court. And you're looking right at it. The law does not displace a general rule. Oh, that's real handy. That's the basis for the taking of property from everyone who sells services by the IRS. You're looking right at it. It's a general rule. I wanted to make this expose since Christmas of 2017. I'm finally getting around to it. And it's time to throw some of mine back at the chimps that call themselves judges. They're not better than baby rapers. It's a collective of, what, a couple thousand people in public office that unlawfully make the difference between you having a unencumbered paycheck or having one that the government gets a slice of. It's a general rule. It does not come from Congress. It is unwritten, and they have no problem springing it on you in court when you've relied on just the law. None of this is legal advice. There's no such thing. It's general rules. When the law protects you, they'll pull a general rule out and screw you with it. That's the American judge. That's the baby-raping American judiciary. America's #1 toilet. Every judge. I got no problem saying this. I got all the docket numbers to prove it. Judges rape babies. My name is David Myrland. None of this is legal advice. Anything that sounds like that to you, just consider it something somebody else might do on a planet far, far away where the law matters. It doesn't matter here. I prove it on a daily basis. Advice? Yeah, stay in the system. File tax returns, start a home business, gather all allowable deductions. Because if you think the law protects you, they got a general rule in the toilet they call a soul that'll screw you right into the ground and into prison if they have to get that money, to change your mind. That's the American judiciary. I'll see you in the next tutorial. Thanks for visiting. Take from Caesar.